Children of the Torn. Several months ago, a commentary was done on the children of Luzerne County, Pennsylvania, where judges sold their very freedom for private profit. Children, some as young as 13 and 14, snatched away from their homes and families and put in jail. Two prominent county judges made millions of dollars by sending kids to private facilities in which they had a financial interest, as opposed to state institutions from which they would have received nothing. How could such a thing happen? How could it have happened for years? It happened because, in part, people both allowed it to happen and they wanted it to happen. Children were sent to juvenile prisons for months, for hookieing school, for being late, for breaking curfew, and the like. And most people said nothing, did nothing, and some even praised this judicial example of zero tolerance. One woman, Sandra Brulo, the former chief of the county's juvenile probation department, asked about the increasing detentions, told a county commission looking into the scandal, the judge is the final say, adding that most folks simply didn't want to question the judge. And so they didn't, while dozens, then hundreds, and then thousands of kids were sent to detention. Nobody wanted to rock the boat. It's enough to say it was illegal for judges to privately profit from the juvie prison system. But the Pennsylvania Juvenile Act, the statute governing this area, made what those judges did illegal as well. That's because the code, Section 6337, states lawyers must be provided for kids unless a parent or guardian waives such counsel in open court. According to Brulo, in many cases, orders for detention were signed by the judges before the hearings even began. Moreover, in 1966, in the case Kent v. U.S., the U.S. Supreme Court affirmed the right of juveniles to have counsel just like adults. For years, in Pennsylvania, this meant nothing. What use is the Constitution when there's money to be made? From death row, this is Mumia Abu Jamal. These commentaries are recorded by Noel Hanrahan of Prison Radio.
Federal authorities have charged 2 Luzerne County judges with violating the trust of their elected positions and with defrauding the federal government and the citizens of Luzerne County of millions of dollars. Investigators say the judges have entered a plea agreement and will serve more than 7 years in federal prison for what they describe as an elaborate scheme in which they use the power of their offices to enrich themselves.
This office has filed a 2-count criminal information charging President Judge Mark A. Chivarella and former President Judge Michael T. Conahan. The judges have been charged in this criminal information with conspiring together to impede the Internal Revenue Service in its collection of taxes. And the judges have been charged together with having devised a scheme to defraud the citizens of Luzerne County and the people of Pennsylvania of their right to honest services by judges by concealing the receipt of more than $2.6 million.
Federal and local investigators were grim as they revealed counts against Luzerne County President Judge Mark Chivarella and former President Judge Michael Conahan. Their ongoing investigation revealed the jurists allegedly conspired in an honest services fraud scheme, which apparently involved taking payments for the placement of juvenile offenders into certain detention facilities.
These payments were made to the judges, it is alleged, in return for discretionary acts by the judges favoring these businesses, acts relating to the construction, expansion, operation of these juvenile facilities, and acts relating to the placement of juveniles in these facilities.
According to the criminal information filed in federal court, between 2002 and 2007, the judges allegedly took a series of steps to guarantee the closing of the old Luzerne County Juvenile Detention Center in Wilkes-Barre, and then ordered young offenders to be housed in the Pennsylvania Child Care Facility in Pittston Township, as well as in a Western Pennsylvania facility owned by the same company. Investigators say that in return, millions of dollars from unnamed sources were channeled to companies in which Chivarella and Conahan had control, a fact which investigators say they allegedly hid from the IRS.
The defendants received payments into these businesses that they controlled, and in some instances falsely identified payments that they received as rental fees for a Florida condominium. The information charges in a second count that the defendants, through these actions, conspired to impede the Internal Revenue Service by making false entries in business records and falsely characterizing the monies they had received.
U.S. Attorney Carlson also announced that based on the charges filed, both judges had signed a plea agreement by which they would plead guilty to fraud and conspiracy counts, serve 87 months in prison, and pay some restitution. Chivarella's legal counsel responded by saying the judge would not plead guilty to all counts in the federal presentment. However it unfolds, investigators say this was a dark day for all who are sworn to uphold the public trust.
The defendants in this case, as the information that was filed today shows, they sold their oath of offices to the highest bidders and engaged in ongoing schemes to defraud the public out of honest services that were expected from them.
Federal authorities say that the investigation here in Luzerne County is ongoing. As is standard in white-collar investigations, Judges Chivarella and Conahan remain free and will be notified of a time and place when they should turn themselves in. Kathy Baczynski, TimesLeader.com.